Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
Good to see you all and welcome back. We are now in our third installment of 5. So we'll have 2 more to go after this. And this series is Win Before You Walk In. The whole concept is that most cases resolve before you walk in to try a case, pick a jury, and leave it in the hands of a jury to decide the fate of your clients. So most of the cases are won before you walk in. And this series is to go through those phases where I think you can have the most impact on trying to win your case and posture it for a successful resolution for your client. So in part 1 and part 2, we talked about what to do before filing a lawsuit, how to frame your complaint, investigation, attempts to settle the case. Today, we're going to talk about the real meaty part of litigation, and that's discovery techniques and the importance of a good deposition, because this is the battleground. This is really where cases are won and lost. We're going to talk about that today. Next month, in part 4, we're going to talk about building and proving damages to either increase or decrease the value of the case, depending on which side of the V you are on. And then lastly, in part 5 in May, we will talk about motion practice and how that will have a big impact on the resolution of your case. Before we get into the details today, I want to go over a couple of just sort of housekeeping matters, ground rules. The first is, I always like to say, if you are not currently a member of the Academy, the New York State Academy of Trial Lawyers, please join us. Please join in and become a member. The CLEs are free, and there's so much more that you can get once you become a member. So Michelle just put the link in. You can get involved on our boards and our different groups that work on things. It's a fantastic organization to become a part of. And once you join, maybe you'll do a CLE with me. So think about joining. I hope you do. And the other thing I want to let you know is that I will answer questions from 2 to 2:30. So stay on after the main hour from 1 to 2. Then I'll answer some questions, and I will try and answer some questions during the hour if I have the opportunity, but there's a lot of material to cover here. So hang in from the extra half hour afterwards, and you could also get additional credit by staying on. In the meantime, please, as the CLE continues, type in your questions to the Q&A. That's what I'm here for, to answer the questions that you have. So if you're sitting there and you've got something spinning around in your head that you're wondering what the answer is, and you're waiting for me to address it and I haven't, drop it in the chat. Also, we are a community here. I don't profess to know everything. I just am here to share my knowledge over 30 plus years as a practicing trial attorney. So if you have comments to share or thoughts, please put those in the Q&A as well, so we can all benefit from your knowledge and the combined knowledge of us as a community. Lastly, I want to talk about just some additional resources that you have with me personally. You are always available to meet with me. I conduct complimentary Zoom one-on-ones for 30 minutes where we can talk about your cases, evaluation, marketing, anything, race car driving, whatever you want to talk about. It's free, and I'm happy to meet with you. What you can do is this to my side here where it says scan for more. If you hold your camera from your phone up closely, it'll have a little button to press that'll open up to a website which has all my information, including a link to book the one-on-one. Also, I have 2 books on Amazon on trial skills and how to litigate a personal injury case. The proceeds of that go to my charitable causes. Those are good resources. People often ask me of books that I'm aware of to help. And as Michelle mentioned, my podcast, the Mentor ESQ podcast, has a lot of additional information, and you could also get CLE credit from it. All right, now let's get to today's topic. Discovery. Discovery is it's where you peel away the layers of the onion. It's where you take off those Russian dancing dolls from the bigger ones to the littler ones to get to the bottom of it, to get to the juice of your case, of what's going to win or lose your case. This happens in discovery. Discovery is where we get all the answers to the who, what, why, where. How much? How strong is our case? When we all start in cases, whether on the plaintiff or defense side, we have a general idea of whether we think the case is stronger for us or our adversary. We have a general idea of what we think we'll be able to prove or disprove. But it's not until you get into discovery that you really find out, not until you request those documents that you don't have. Look for those key pieces of evidence that are going to support your claims, support your defenses, or refute your adversary's claims or defenses. This all happens in discovery. So you can't count on your adversary just voluntarily giving you everything that you're going to want or need. They don't know where you're going with the case. Only you know where you're going with the case. So you need to demand certain documents. You need to take depositions of the right people. And through doing this discovery, the paper discovery, the depositions, this is where you're going to build your case. And ultimately, where you're going to win or lose your case is going to come from everything that comes out in discovery. And you have that window of time from when the answers are filed. We left off last time talking about filing the complaint and serving it. Now we're going to pick up with where you go once issue is joined. That's the legal terminology. Issue is joined when all of the parties in the litigation have appeared and answered. So if you are the plaintiff and you filed a lawsuit against one or more defendants, then once you get the answers from those defendants, issue has been joined, and then you're ready to get into discovery. So what you need to do is you need to let the court know that, hey, we're all in, papers have been served, and it's your job. If you're the plaintiff's lawyer, preferably, you're the one that's anxious to move your case forward, but the defense can also do it. And what you want to do is once issues joined by everybody, you file for a preliminary conference. That's what we do in state court litigation here in New York. And generally, there's a proceeding around the country in various states to file that first document to get a conference, to talk about a discovery schedule. And this can be the initial meeting that's done in court. Sometimes it's just working out a stipulation for the discovery deadlines and uploading it. Every state, every county, every jurisdiction has their own process, but ultimately you will get some type of a framework, an order. Usually it's a preliminary conference order. In federal court, it's called a case management order. And either way, whether you're in state or federal court, once everybody's answered and you have all the parties in, that's the next step, is you want to file for a conference with the court to set up the discovery schedule. But also, you don't need to wait for that conference. You don't need to wait for a discovery schedule to get out those demands you have, to start serving demands. So you want to think about the fact that if you're on the plaintiff side, it's your obligation to move the case. You need to get everything going. And the longer you wait to conduct discovery, demand discovery, conduct depositions, the longer it's going to take to resolve your case. All right. So if you are the move-in, if you're the one bringing the litigation, you should be the one moving on it. And if you've got so many files in your office or in your firm that you don't have the time to make sure that all your demands are out timely, then that's a problem. You need to work on that. But you need to get your demands out immediately, regardless of whether you're on the plaintiff side or the defense side. And when I'm talking about demands, I'm talking about demand for a bill of particulars, talking about demand for insurance information, talking about demands for medical records and authorizations, demands for, if I didn't say it already, insurance coverage through 3101 subdivision F, demands for experts. So demands for notice of discovery and inspection. Generally, if you're on the defense side, you can attach those demands, and you should, with your answer. Deposition demands, notices for deposition, demands for bill of particulars, authorizations, all of that. And as a plaintiff, I will often see all of those demands attached to the answer when it is filed and served. And I think that is the proper way to do it. Get those out. put the burden on the plaintiff. It's, okay, you're bringing a lawsuit. What have you got? Give me your medicals. Give me your authorizations. Give me your records. So on the defense side, you have first strike with demands, with your answer. And you're going to want to get that information to start assessing the case that you're defending. On the plaintiff side, once that answer comes in, start responding to those demands. Okay. I don't understand plaintiffs' lawyers that do not respond to demands, that are slow in giving information, and who do not serve their own demands timely. When do you think your case is going to get resolved if you're not giving your adversary what they need and you're not making the demands for what you need? So if you take anything away from this CLE today, it's that you need to move your cases. No one's going to move them for you, okay? Whether you're on the plaintiff or the defense side. And that starts with getting out all of these demands, diarying 30 days in your calendar, that if you haven't gotten an answer, to send a follow-up, okay? But you need to get your demands out ASAP. Let me talk about the materials for a moment. If you've attended any CLEs with me previously, you know that I don't go through my materials for the most part because I prefer to be engaged and speak with you and chat. You're welcome to look at the materials during the CLE or save them to reference afterwards. But I'm going to tell you now what's in there so you know what you've got. I always try and give you good materials, practical materials, because I attend CLEs also, and I always want good materials to save. So when I'm talking about demands, in the materials, I have samples of all of these demands. Feel free to copy them, use them as you see fit. All right, those are in the materials. We're going to talk about depositions today as well. And in the materials, I have a chapter from my book. One of my books on depositions is in there. So take a look through it. I think it's really helpful. Gives you some insight into what the book is like. So if it's helpful and you want, grab the book to get more information and other topics. But I have a whole chapter on depositions in the materials. I also have samples of depositions I've taken of various witnesses that are in there. So if you want to see my technique, how I handle things in a deposition, the questions that I ask, the way I deal with objections, you can take a look through those transcripts. Also in the materials are all the forms, requests for judicial intervention that you need to file when requesting a conference, all of that. So lots of good information for you in the materials. You don't have to look at them now, but know that it's there for you to use as samples and also as guides for what you're going to do. All right. All right. So you have to remember that the information you get from discovery is what you're going to use in your motions. It's what you're going to use at trial. And sometimes you have to go all the way through to trial and get a jury verdict, to go all the way through with motion practice and appeals, to realize the importance of a good deposition and the importance of getting good discovery. Okay. And so that's where I'm coming to you from, because I've gone from the beginning to the end in so many cases over these years that I've realized the importance, the real importance, because when you're doing a deposition or you're conducting discovery, you already want to have an idea in the back of your mind of where you're going with the case, of what motions you think you're going to make. Is it an automobile accident and you want to make a motion for summary judgment? Okay. And you know it's a straightforward rear end collision. Well, if you're the plaintiff, you know you're going to want to make a motion for summary judgment at some point on liability. If it's a rear end case, you should be able to get it. But what's the one thing that maybe the defense can come up with? Would be a non-negligent explanation for the rear end. So in the deposition, you have to ask questions. Do you have an explanation? Make sure you elicit that, okay? Because you know in the motion, you're going to want to say, we asked for explanations, and here's what the witness said, and they couldn't give a non-negligent explanation. All right, if you're on the defense side and you're preparing your witness, you want to explore, do they have a non-negligent explanation? If they do, make sure that comes out. If they don't, then they don't, and you're working with it. But the idea is that going into depositions, you have to think about what motions you're going to make so you can ask those right questions in the deposition. If it's a medical malpractice deposition, if it's a premise liability deposition, if it's a product liability deposition, you need to know the elements of your case. What do you need to make out a prima facie case? Okay, meaning if the defense is trying to get your case thrown out because you haven't laid out all the elements of your case, this is getting back to the basics. What do you need to establish to win an automobile accident case? All right. Negligence. In a premise case, you need notice. You need a dangerous condition. They either have actual or constructive notice. You need to ask questions about that in the deposition. You need to demand in discovery information going to notice, whether it's constructive notice or actual notice. If it's a product liability case, you're going to need to learn things about the manufacturer, the distributor, okay, about warnings. So these are things you're going to want to ask about. If you're questioning an expert in federal court in discovery and you think you may want to move to preclude that expert, then you need to be familiar with the case law on what you need under Rule 702 in Daubert to preclude an expert from testifying, and make sure you ask those questions. So know the ground rules of your case before you engage in discovery, and that will help you in determining what things you need to demand. All right, so when you're getting out your demands, you need to put thought into them. I like to talk about general demands and specific demands. So a general demand packet, and you'll see a lot of this in the materials, is a notice of discovery and inspection would be, statements, reports, videos and photographs of the plaintiff, witnesses. They're sort of general demands that will often be sent out, which are fine. And you can always do those to get that initial packet out the door. But what I suggest that you do, either in addition or in lieu of the general demands, is have specific demands depending on the subject matter of the case. So, for example, if you have a construction accident case as the plaintiff, there are a lot of things you're going to want to demand that are specific to a construction accident case. You're going to want to know about the general contractor, the subcontractors. You're going to want all those agreements and subcontracts and invoices, contracts between co-defendants. You're going to want to see daily logs from the construction site, photographs. You're going to want to get toolbox talks, memos, safety training information, all kinds of stuff that are specific to what goes on at a construction site. And you can find that if you've done it in other cases, or you reach out to a lawyer who you know has handled those, like me. I'm always happy to share a sample of our demands with anybody if you reach out to me. But if it's a medical malpractice case, you're going to want all the medical records from those treating providers specifically that may not be available in the patient's chart. If it is a premises case, again, you're going to want to put in your demands, information on who the maintenance companies were and who the workers were, and schedules for clearing ice and records of all of that. So you have to think about the specific case to determine what you want to ask about. Now, this is where experts early on can be really helpful. If you know in your case you're likely going to need an expert, okay, let's say it's a product liability case. You can't pursue a case in product liability without an expert. So depending on the types of products, and you want to figure out the design process, the warnings, the manufacturing process, you're going to want to speak with your expert and ask your expert, what do you need? What would you like to see to help us in evaluating this case? And that expert may say, oh, I definitely want to see the initial design plans. They need to file these documents when they come up with this new product with the Consumer Product Safety Commission. So demand copies of what they filed there. So there are going to be things that we don't know as lawyers in a specific case that an expert may know. So it's always great to get an expert on board and ask them, say, I'm sending out demands. Can you tell me specifically what I should demand? And a great way to phrase it is, what would you like to see? Okay, what information should we request that will help you? All right, so make sure you get your experts on board early when it comes to liability, and they're going to help you determine what kind of demands you want to send out. All right, so make sure you do that, and make sure you get responses to your demands. Okay, this is often an area of frustration I speak with a lot of lawyers about, and they'll reach out to me. What do I do if I just get blown off, or if they say object to the demand? It's vague and overburdensome, and all the boilerplate objections that we often see in response to our demands? Well, you need to meet and confer. This is in state and federal court, and try and sort it out. Reach out by phone, by email. Is there some middle ground we can meet here instead of you just blanket objecting to my demands? What are you willing to give me? What do you have? What don't you have? Ultimately, you need to take that interim step. And if you still don't get what you believe you're entitled to, then you need to make a motion. In state court, it's a motion to compel the discovery. You simply make a motion, you attach your demand, you show that you've made an attempt to meet and confer, and you ask the court to compel discovery. In federal court, you can simply send a letter to the court, to the magistrate, saying that we have a discovery dispute, we met and conferred on this and this date, and we can't agree. And usually you'll get a conference set up, a virtual conference, pretty quickly, usually within a few weeks in federal court. State court, it's going to take longer, and it's very frustrating because you can file a motion, right, for discovery that you need, and then you're sitting waiting for months and months and months. But that's what you have to do. You have to push for your discovery. It includes getting the photos, the videos, the documents, the reports, whatever it is that you're pushing for. It's also getting insurance coverage. You know, under the federal rules and the CPLR, you're entitled to full insurance policies, not just the name and the amount of coverage. You're entitled to the contact information for the claims adjuster on file. You're entitled to all applicable policies, excess policies, umbrella policies, any policy that may come into play. So look for those responses. And if they give you just the name and the amount of coverage, write back and say, pursuant to CPLR 3101F and the Disclosure of Insurance Coverage Act, you know, you need to provide this to us. So don't just sit back. It requires us as advocates in discovery to serve demands, serve supplemental demands, push for the answers until we get them. And then if we don't get our responses, then you have to push and use the judicial system and file motions to compel it. If you're on the defense side, you need to provide real answers to the demands. Discovery is very broad, and you're entitled to get things that are not admissible. It just has to be relevant and could lead to more discoverable information. So I get very frustrated when I get responses to legitimate demands that we serve without any actual response. It's all just objection, objection, objection. You are obligated to give a good faith response on the defense side. And if you feel that you're not required to, whether it's something that's privileged or so far afield, then you need to move for a protective order. That's the way our system works. All right. So if you don't move for a protective order, you may run into an issue with the court, and they're going to require you to give everything. All right. Same thing on the plaintiff side. You can't just object when the defense demands certain things from you and your client. If you feel you have the basis to properly object, then move for a protective order. If not, you have to be prepared for motion practice. But you always have to justify truly not giving a discovery response. And if it becomes a pattern of practice where one side is just refusing to give discovery that's being sought reasonably, then that can be sanctionable. So whether you're on the plaintiff side or the defense side, you need to give discovery responses or move for a protective order. And if you're not getting the responses that you believe you're entitled to, don't wait around. Push, and then make a motion to compel. All right?
Attendance code number 1 is WIN 034. That's WIN 034.
All right. Now, let's just talk a little bit about bills of particulars, and then I'm going to move on to depositions. Bills of particulars go both ways. The defense will normally serve a demand for a bill of particulars with the answer upon the plaintiff. The plaintiff should also be serving a demand for a bill of particulars as to the affirmative defenses that are filed by the defendants in a case. Now, remember, in litigation, both sides usually have burdens of proof. The plaintiff will have the burden of proof to make out a prima facie case. They have the burden to ultimately show to a court or to a jury that they have satisfied the elements of a duty, of a breach of a duty, of harm and injury and causation, okay, and damages. All right. So you need to push for that. And that's why that's why a demand for a bill of particulars from the defense is entitled to ask all those elements. Okay. They're entitled to ask all about the different injuries, about the treatment, about medical records, about witnesses, about everything that go to the elements of the case. Similarly, the defense has a burden of proof to prove certain defenses. Okay. To prove a defense of culpable conduct is probably the main affirmative defense you'll see and have to deal with. There are many other affirmative defenses, but again, if something is raised as an affirmative defense, then that burden of proof shifts to the defense. All right. So as a plaintiff, you are entitled to demand a bill of particulars as to affirmative defenses. Okay. And we like to always push very hard on those and make sure that we get a response towards a demand of bill of particulars for culpable conduct. It's not enough to just put in boilerplate language that the plaintiff, should have been careful and aware and all of that, but there has to be actual statements of where they were negligent. What did they do that departed from reasonableness or the standard of care? So both sides should always pursue a demand for bill of particulars and then follow up and make sure you get a properly submitted with information bill of particulars in response. Now, on the plaintiff side, fill it all out, put it all out there. That's going to be the document that the defense is going to rely upon to assess your case. Always list the injuries. Always put the most serious injuries first. The surgeries, we always list up top, okay? Put the surgeries in there. Put the medicals in there. Give the authorizations that are demanded in a BP with a separate document providing authorizations. I've always been of the belief that on the plaintiff side, you have to give everything to the defense, because what else are they going to have to evaluate to pay you what you think your client's entitled to compensate the case? You got to give them everything. So do it. Don't hold back. And on the defense side, you have to show if you've got a legitimate basis or not for your affirmative defenses. And the plaintiffs are entitled to demand that because, again, you're setting up motion practice, which we'll talk about at the final installment of this series in 2 months. But you're setting up the motion practice to move to dismiss an affirmative defense. Or on the defense side, you're going to move to dismiss the plaintiff's causes or a cause of action because they failed to put forth evidence to support it. All right. So work hard on your discovery. Put thought into it. Put thought into your demands. Take time. Put thought into your responses, and make sure to follow up and see if other things come out offered at depositions. It's going to lead to other potentially discoverable information. So send a supplemental demand. You are entitled to send follow-up demands. It's not uncommon. We'll have our notice for discovery and inspection, plaintiff's second notice, plaintiff's third notice, plaintiff's supplemental notice. Okay, you're entitled to continue. It's not a one-shot deal. You can continue to ask and ask and ask. And I encourage you to do so because cases take on their own sort of life form. Oh, maybe we should go down this path. We got some good responses there. Let's see if they have records about that. Then you send a follow-up after a deposition. All right. So make sure to continue to get everything you want before you certify that discovery is complete. That's done in state court, usually by the filing of a note of issue. But whatever it is, make sure before you certify you're ready for trial that you have gotten responses to everything that you want and that you have served demands for everything that you want and feel you need for your case. And now depositions will generally come after a first wave of paper discovery goes back and forth. So the demands are served early on, responses are given, and then usually depositions will take place from there. There's often a battle about whether or not one side's ready to move forward with depositions. When we're trying to move our case forward, we get frustrated if on the defense side, they're not ready to take our client's deposition. They'll say, we don't have all the medical records yet. And we'll say, well, we gave you authorization 6 months ago. We gave you all the medical records 6 months ago. And then we'll usually get a response, well, we like to get our own records and we don't have every little bit that we've served. So I think there's a middle ground there. I think as long as the defense has all of the main records, even if they didn't get them themselves, but they've got the hospitalizations, they've got the operative reports, they've got everything, you shouldn't hold up discovery because one provider hasn't given you records, and you shouldn't delay depositions. So I always suggest take the deposition, get everything that you can, and we'll give you the leave to conduct a further deposition when you get those medical records if you feel you need it. Usually it's not needed. So it helps you move the case. But, for the most part, plaintiffs' depositions go first. They should go first. And you should make sure that you've given your adversary all of the records so they'll be prepared to pursue it. Similarly, before you conduct a defendant deposition, you want to make sure you've gotten at least the first full round of discovery responses that you can then question those defense witnesses upon. You don't want to start doing a deposition of a defendant in a case where you've got no discovery. It's a waste of time. All right. So you need to push for that on any type of case. If it's a premise liability case and you haven't gotten any records of who the right personnel was, of who was in charge of clearing things, of what the schedule was, then what good is it questioning a witness with no information? Look, the reality is sometimes you're not going to get information, and it's going to be the deposition that will help you identify where records are and what records exist. So sometimes you need to take the deposition of a witness just to lay that foundation for requesting additional information. So you have to do that. But the idea is try and get a good handle on your case and the information that's out there, because to have a really good deposition and to take a good deposition, it's important you've got the information, you've got photographs, you've got records, you've got incident reports. You're going to need all of that. I wouldn't want to take a deposition in a construction accident case unless I've got the contracts, unless I've got some photos or videos or log records or reports of the incident to question the witness about. It just makes sense. You want to be productive, and you have to find that balance as a lawyer, whether you're on the plaintiff side or defense side, of moving your case forward, but also making sure that you're not skipping steps and you have what you need to properly move forward. So again, find that balance so you can move forward and take depositions, knowing you may have to take a follow-up deposition, but try and get all the records that you can before the deposition. All right. And then once you have all of those records, then you need to properly prepare yourself to conduct a deposition of the witness. So if you're the plaintiff and you're preparing to conduct a deposition of, let's say, the person who was driving the defending automobile, or the person who was the maintenance person who was charged with clearing away the snow and ice, or the person in charge of site safety at the construction site, or the person that manufactured or designed a certain piece of equipment, you are going to want to properly prepare for that deposition. And the way that you do that is you sit down with all of the discovery and you look through all the responses that you've received and you organize them and you look through and find out the things that are important. And based on that, you create an outline. Okay. Outlines are super important before you move forward with a deposition. The outline is going to give you your flow, and it's going to tell you what you need to ask, and it's going to help you identify the important points in documents and help you prepare for the deposition. So what I like to do before a deposition is I'll work on the outline in advance, and then I'll look through all of the records that I want to question the witness about. I'll make a subfolder on my computer. I conduct probably 99% of my depositions via Zoom these days. I know there's more and more being done in person, but what I'll do, and if I have to do it in person, I will. I'll bring my laptop. I'll still organize everything, and I will organize all my exhibits for the deposition in a folder, and I'll pre-mark them 1 through however many they are. Let's say there's 5. So let's say I'm going to question a witness in a case where there's an incident report, there's some photographs that were taken, and I want to question them about a 2-document incident report and 3 photos. So I may pre-mark the incident report as Plaintiff's Exhibit 1. I'll save it Plaintiff's Exhibit 1, Incident Report. Then there's 3 photos. Exhibit 2, photo of accident scene. Exhibit 3, photo of a repair or whatever it may be. Then you have them all saved and organized, and then you have your outline. And then in your outline, you'll say, go to Exhibit 1, Incident Report. And then you'll have the questions under there. Direct you to page 1. Is that your signature? Direct you to page 2. Read description of incident. Direct you to page 2, middle of the page down where you say photos were taken. What photos are you referring to? So by getting organized, that's going to help you in your flow. You never want to show up for even what you think is going to be the easiest of depositions without some sort of outline. All right. Even a basic auto accident case, you should have an outline of background of the individual. You're going to want a section on the vehicle itself that's being operated. What type of vehicle, make, model, when have repairs been done? Was it in good working condition? Any problems with the brakes? You're going to want a section on where they were coming from and going to. You're going to want a section on weather conditions, section on who is in the car, and then the event itself, right? Time and distance questions. So it's really important that you put in the pre-work for a deposition before you take the deposition. And that is one of the most important things you can do in a case. That's the time where you sit down with your outline and maybe look at what the elements are of the prima facie case that you need to make. What do you need to have for your summary judgment motion? You're thinking, I want to move this case. What do I need from this witness to insert into my summary judgment motion? Right? I have a pending case. I'm waiting on a decision now for about 8 months in federal court. It was a product liability case. And in federal court, we were able to take the depositions of experts. And I remember specifically going over what I need to do to prove the elements of a defective product so that I could ask the defendants multiple experts and get the answers from them in the deposition that would support my claim that it was a defective product. What questions do I need to ask them about design, about testing, about warning, okay? And I'm picturing that motion for summary judgment. I'm picturing that Q&A right as I'm hearing that answer from them. I'm like, that's a great answer. And then I can't wait to do the motion, and then I'm going to take that Q&A and put it right into the motion. So these are the things you want to think about. Deposition serves multiple purposes, all right? It's going to serve the purpose of getting information to lead to other discoverable stuff. It's going to help you lock down and confirm information to make out your case. It's potentially going to be for information to rebut or eliminate one of the adversary's defenses. It's to knock out a witness. Sometimes a deposition is just to make sure that this witness, you ask all the open questions so nothing's going to surprise you. Sometimes there may be a witness to an accident and you don't know if they're going to help or hurt you, but you want to know what they're going to say. So you're going to ask all these questions. Well, what did you see? Did my client say anything? Did you hear the other client? I call these knockout depositions, just to get everything out there. We don't want surprises at trial. So that's why for depositions, you're always asking open-ended questions. Don't be afraid to ask any question, for the most part, in a deposition. Ask the who, what, where, why, when, and what happened next, and what did you do then? You just want to ask all these open questions, okay? You want to ask their explanation. Do you have an explanation for why you ran into my client? Other than that, they stopped short. Any other explanation? And you're asking that, let them come up with what they're going to come up with, okay? Some people say, well, if you ask them that, can't they then say, well, your client cut them off? And yeah, of course they can, and you want them to, because then you can follow up. Okay, you're saying my client cut you off. When did they cut you off? Where did they cut you off? Where were you? Where were they? And you're going to drill deeper. But you need to ask these open-ended questions in depositions so you can at least know what these witnesses are going to say. And you need to ask the questions that you're going to be able to use those answers in motion practice. All right. So you need to do your homework before the deposition of what do we want to get out of this witness to help us find other discovery? What do we want to get to lock them into points that help us? What do we want to get to lock them into something that's going to help us remove a defense or weaken it? And what do we want to get just information about to knock them out as a witness? These are things that you want to think about when you're questioning a witness and preparing to question a witness. All right. There may be certain negatives, certain bad things, what weren't in place, and you want to ask them about that. Okay. What didn't you do? What didn't you see? All right. Generally, the flow of depositions, the outline is chronology. You want to go sort of beginning to end and end at the accident scene. If it's an accident case or any type of case, try and have a logical flow. Okay. And the goal of every deposition is locking in the witness so they can't change their story. If they do a trial, you're going to impeach them. Get admissions that are going to help your case. Establish the full extent of this witness's knowledge. I often ask questions like, is there anything else you know about what happened here that you haven't told me already? All right. You always want to tie up those loose ends. You want to take a break and review your notes. Okay. Now, let's talk about in the deposition itself for a moment. When you're in the deposition, there's what's going to be at the beginning with the court reporter. They're going to talk about the usual steps, usual stipulations. And most lawyers say, yeah, usual steps, usual steps. But the same lawyers that say, yeah, usual steps will then proceed to object for all kinds of various reasons that there's no need to. I've included in the material the usual steps that are put in state and federal court. You don't need to look at them right now, but what you do need to know is that for the most part, you don't need to object during depositions. All objections are preserved for motion practice and trial, except for objections to form. Those aren't preserved, and frankly, they don't matter because you can always rephrase something at trial. And an objection to form is like a compound question. You can't ask two questions at once, for example. What time did you get up, and then where did you go when you woke up? Objection of form. What time did you get up? Next question, what did you do when you woke up? So you can object to form, but you don't need to object to anything else. It's preserved. And it's very disruptive to object to somebody while they're asking questions through a deposition. Okay? Sometimes it's okay to object or to throw them off or to protect your witness if they're being beat up or harassed. But for the most part, you really have to let your witness answer, and you can't object. Speaking objections are not allowed. Objection, you can't ask this witness questions based on that because, and then you go on and on. You're just wasting time and you're increasing the cost of the transcript because a court reporter sitting there taking it down. I'll never forget a long time ago when we had a lawyer in our firm who doesn't work with us anymore. But that lawyer conducted a deposition and got into an argument with an adversary. And it took up like 6 pages of the two of them going back and forth of what they're not agreeing about that the witness can or can't answer. And I spoke to my associate and I was like, what are you doing here? You realize that you just cost us an extra $15 just to have a transcript of you arguing and getting nowhere. Depositions are not the places for argument. You make your objection, you make your record, okay, if you need to, but then you move on. All right. So the usual steps, that's what they're saying. When you're agreeing to usual steps, it's saying for the most part, you don't need to object. I had a case once. I was questioning an expert in federal court. And literally after every question I asked, the defense said, objection, vague, broad, ambiguous, and maybe 3 other things. Literally after almost every question, where I said, listen, counsel, you don't need to object. The usual steps you agreed to. And I will stipulate to make it clear in the record right now that you have a preserved objection to every single one of my questions, so you don't need to keep saying it every single time. And he said, no, I'm going to keep making my objections. And if I wanted to, I probably could have gotten the judge on the line, but that's just being abrasive, and there's no need for that. Speaking of which, there's pretty much not a day that goes by in this profession where I don't hear from someone in my own firm or from one of you in a one-on-one meeting about having a lot of acrimony, fighting, nastiness between lawyers, which I'm trying to, in general as a community, try and bring the temperature down and remind all of us that we're all just doing our job. Okay. Yes, it's an adversarial type of work we do in litigation, but we could be adversaries and be really pleasant to each other also. And for the life of me as a plaintiff's lawyer, when I know I'm going to ask an insurance company or defense lawyer for money at some point, being nasty is not going to get you very far, and I can't imagine doing that. Depositions are generally going to be the first time that you have of an actual face-to-face interaction with your adversary. And I suggest that you use that opportunity wisely to make a nice connection, to understand everyone's just doing what they got to do, to give each other some grace, some courtesy, and to not be a jerk unless you're really forced to be a jerk. And it's also a great way to get off on the right foot to move forward with the litigation. Hey, are you the lawyer who's going to be handling this moving forward? Great. Tell me what you need. Thanks for getting this deposition done. When's the next one? What can we do? Maybe we can move this case. What do you think? Does your carrier like to resolve? If you're the carrier, do you like to resolve cases early? My carrier would be interested, but we need to get the IME going. So the deposition is usually a really good time to try and establish some type of rapport, because up until that, it's usually just phones and emails, and you can read tone improperly into that, and that can be a problem. So once you meet your adversary at the deposition, it's a really good opportunity to move forward in a positive way. One of the things I'm not going to talk about today is how to defend a deposition. I'm pretty sure that there's a CLE on demand with the Academy where I've talked about it, about how to properly prepare your client and how to conduct and defend a client. I'm not going to talk about that today, because the goal of today is what you can get when you take a deposition and the importance of it. Again, before you get into that deposition, whether you're speaking with your colleagues or you want to reach out to me, do your homework on what you want to try and get from the witness, because it's going to it's going to become a breathing document in your case, the deposition transcript. It's going to be referred to in motion practice. It's going to be used at trial to refresh and impeach. It's going to be used for you to try and figure out theories of your case. So you really need to put in that time in advance. And if you do that, it's amazing what can come out of it. We have a case now that I won't bore you with the details about, but let's just say that in the deposition, I was able to get a lot of great stuff out of the defense where they talked about the accident that my client had was foreseeable. And they were on the premise, and they acknowledged that it was foreseeable. They could have collided with this dangerous condition. And I purposely went in there with a plan of attack to get them to hopefully acknowledge foreseeability, because if I got that, then I could put it into a motion for summary judgment, say, hey, the defense has acknowledged that what happened to my client was foreseeable, yet they failed to do anything about it. And here's their testimony. And I'm picturing it as I'm questioning them. And you would agree this is foreseeable? And they say yes. And the minute I hear that, I'm picturing the Q&A from the transcript in my motion. So that's the way you want to start approaching these depositions, and that's how they're going to end up helping you with your case. It's always a good deposition. And then when you get to the time of trial, either if you're going to try the case, if you need to, or someone in your firm, they're going to be really happy that you did such a great, thorough deposition. But hopefully, since this is a program about win before you walk in, that deposition is going to have done its job, and you're going to have earned your money, so to speak, by being able to use it in a motion to support or refute a motion for summary judgment to help you either win your case or fight back a motion to dismiss your case. That's ultimately the key now, because as we all know, and we'll talk about in 2 months at the last meeting in the series on motion practice, is that usually it's when the motions are pending, cases get into mediation, they get settled, or if the plaintiff's granted summary judgment on liability, there you go. Then you're just talking damages. Obviously, on the defense side, if you win the motion to dismiss the case, then you're done. You've won the case. So great deposition can do that for you. All right. So now I see the course evaluations are up. After you finish giving great evaluations, let me now look into the Q&A. Please stay on and please put into the Q&A questions you have that I have not answered, and I'll be happy to answer them now. And also feel free to reach out to me anytime for a one-on-one. And I'm happy to chat with you about anything related to this CLE or anything else that comes of mind. Okay, so let's start at the beginning now with the first question is from Lewis. The question is as follows. How do you respond when the opponent does not answer a bill of particulars, except to claim that the demand is not appropriate, but should be made through disclosure, and you believe that your demand is appropriate? So, Lewis, I did touch on this. You pick up the phone. You know, one of the things that we all can be much better at is picking up the phone and answering and returning phone calls. People just are really bad about returning calls and emails. I encourage everybody to do your best to return phone calls and emails within 24 hours, even if it's just a quick email saying, just want to let you know, I got your email. I've been slammed. I'll get back to you by the end of the week. Or just to let you know, I got your message. I've been slammed. I'll get back to you by the end of the week. Try and do that, everyone. It goes a long way. It's really frustrating when we all send 3 emails, 3 voice messages, and simply just get ignored. It's rude. So try not to do that. So what I would do, Lewis, in this situation, pick up the phone, call your adversary, say, listen, you can't just do a blanket objection that you're not going to respond to my bill of particulars. Are you going to file for a protective order? Are you going to give me something? What specifically do you have a problem with? I can rephrase it. Let's work together so I can get what I need and you feel comfortable giving it to me. Otherwise, you have to make a motion. But that first step is super important, Lewis, to do the meet and confer by phone and by email. Oftentimes we'll say, hey, you want to set up a Zoom? Let's meet each other. Let's talk about the case, and remind each other that it's a two-way street. You really want to do blanket objections to my demands? Do you want me to do blanket objections to yours? Of course not. So we both need information from each other. Let's try and work forward and faster and smarter on this. All right. Next question from Stephanie. If you're on the plaintiff side, what do you do with an opposing lawyer who refuses to submit a proposed order after a hearing at which his motion to dismiss was denied? The judge hates it when lawyers schedule hearings on competing orders, but this lawyer, who doesn't usually practice in front of this judge, has refused to talk to me on the phone or to file the order for the judge to sign so we can move along. Should I just begin the discovery demands even though the case isn't at issue? All right, so what I believe, if I'm hearing you right, is that the motion to dismiss was denied, so the judge is asking for like a discovery order, right? Like a preliminary conference or a compliance conference where everybody agrees to the dates. So what you should do then, if they just simply refuse, is first of all, cover yourself. Send an email or letter saying, as you know, I've tried to reach out to you, preferably by email or letter. You have it, so it's documented, and cite all the efforts you've made. Called you on this date, that date, sent you an email here, sent you an email there. Lay the groundwork so that then you could file a letter or motion with the court saying, as per below, I've taken the following steps. The court has asked us to submit a joint order. We are unable to do so because I'm getting no response. So we'd ask the court to issue an order or to have a conference to put an order in and move forward. Otherwise, you just make and at the same time, you should serve all of your demands. You don't need a conference order for serving of demands. So I would do it both ways. Serve all of your demands. You're still entitled to get them responses to them within the CPLR, usually 20 or 30 days, depending on the demand. Keep at it. Document your efforts. And look, if your adversary is going to be the type who's not returning calls or emails, give them a couple of shots. Make sure you take notes of when you've tried to get in touch with them and then slam them. I have no problem slamming an adversary to a judge or to a senior partner. If it's an associate, pick up the phone, call the managing partner of the firm and say, just want to bring to your attention that your associate, I've left 3 messages, 2 emails. They haven't had the decency to respond to me. And I'm going to have to put all this in a motion to the court. And your firm, we have a good reputation. I don't want to have to do that. So I would encourage you to take all of these steps, and hopefully it'll get sorted out. All right, Lei Song, how to best use subpoenas for discovery, how to best do discovery for cases involving social media posts and such. All right, so subpoenas generally are not used in discovery unless it's for a non-party. So you are entitled to demand everything in the control of your adversary that they can reasonably get their hands on. You don't need to subpoena that. Subpoenas are for non-parties. So if you want to subpoena the fire responder for a deposition, non-party witness to a deposition, those types of things. If you want to subpoena records from an entity that's not a party to the case, it's going to need to be a subpoena. In New York and in most jurisdictions, lawyers, we have subpoena power within our own state. You don't need it to be stamped by the clerk or to be so ordered by a judge. An exception is if you want to subpoena a municipality. So in the instance I gave, let's say you want to subpoena a fire department responder, you're going to need that to be so ordered because it's a municipality, the fire department. But if it's a private entity, you could issue the subpoena yourself. The social media question, there's a lot of case law out there. I encourage everybody to read it on what you do and don't have to give as far as disclosure of social media. I generally try and hold off on that. Obviously, you should speak with clients. If you're receiving a demand for social media, ask your client if they have it, what's on it. If it's something you're concerned about, then take a look at the law, see what you do and don't have to give. Sometimes the adversary has to do the deposition first, lay a foundation that they are on social media, that they use it, so you can push back on that. So look at the case law. That really controls, and it's ever evolving. And I'd encourage anybody else who's litigated this, if they're on the CLE, to share with us their experience of what they'd had to give and what they don't have to give. But that's still, social media is kind of, it's not really clear what you do and don't have to give all the time. So I would look into that as well. All right, Andrew Brown is saying, I get that the name and email of the adjuster is mandatory and automatic pursuant to the statute. How does counsel use that information? The carrier is represented, so plaintiffs should be communicating with them directly. So shouldn't be communicating. So what is the purpose of contact information? All right, Andrew, so there's a distinction there. The defendant or a party is represented by counsel. So it's not appropriate for a plaintiff's lawyer to reach out to defendant John Doe, all right? But you are entitled to reach out to their insurance company, and that's what that information is there for. They can tell you, I don't want to speak to you, don't bother me anymore, just speak to my counsel, but you are totally within your rights to communicate directly with the insurance carrier for the insured. So if the insurance company themselves is a defendant in your case, if it's plaintiff versus Chubb, and you're suing Chubb, and the issue is the policy at Chubb, then yeah, you can't call up Chubb directly because they're represented by counsel. But as long as it's not the party who you're contacting, you absolutely can and often should contact the claims adjuster directly. We like to do that if we feel we're not getting through to defense counsel. We call up the adjuster and we say, your defense lawyer isn't getting back to me. We're trying to move this case. We're trying to give you things. We're trying to talk resolution. Maybe you and I should speak directly. So that's what it's there for. And I encourage everybody to use that information. That's why behind the scenes, advocates like myself and the Academy have pushed so hard to have it in the CPLR that you're given that information. Because oftentimes, if we're stuck and the defense firm is not getting back to us, then we have no way to go or to find the insurance company or the adjuster to speak to. So that's why we're now entitled to that information automatically in a case. And it's good to have. All right, Alan. The difference between a bill of particulars and interrogatories, different or use of both? Okay, so in state court litigation, meaning non-federal court, we generally don't use interrogatories. And I know that there's law in there and you can use it under certain circumstances, but be careful because if you use in state court practice interrogatories, that may remove your right to a deposition. I'd encourage anybody with more knowledge to chime in on it, but we never serve interrogatories as a plaintiff in state court litigation, all right? We only serve a demand for a bill of particulars, and we rarely see an interrogatory served upon us in state court. Instead, we get a demand for a bill of particulars. Interrogatories are generally used in federal court. They can be used in state court litigation, I believe, in lieu of depositions. But interrogatories are more detailed. You're going to spell out various areas that you have inquiries that you would like to have answers to, and you spell those out. So they're very different, a bill of particulars and a demand for interrogatories. So they're different. You can have both, but rarely do. You usually don't have bills of particulars in federal court litigation. They'll usually ask you for a demand that will be in the interrogatories. They'll ask, in federal court, you have demand for interrogatories. and you also have demand for production of documents. I think interrogatories is Rule 33, production of documents is Rule 34 in the federal rules. Check me, I could be off. But between those two, the demand for documents will be all the medical records, authorizations, all of that. The interrogatories will ask the type of stuff that a demand for a bill of particulars will have in federal court. In state practice litigation, there won't be the interrogatories. It'll be the demand for a bill of particulars, and then you'll move forward. Hope that answers the question. Hope that's helpful. All right, Arthur is now asking, I think the practical issue with making the motion is the burden. If you object and the other side wants it, they have the burden. If you make an affirmative motion or for a protective order, you have the burden. So you get stuck in this nonsensical conundrum, which is why I think people still do it that way. Object and put the burden on the other side to justify their demand, and that way, and make your objection and weigh your objection is invalid. All right, so thank you, Arthur. So what Arthur's suggesting is, look, put the issue on them. Say, listen, if you're not going to give me this, you need to make a motion for a protective order, which is true. But the reality is if they're not going to make that motion for a protective order and you still want that information, you have to make the motion to compel. And one of the things you should put in there is they have failed to move for a protective order or for any other relief or court authority authorizing them not to give us this information. So that's the way that I would handle that. Okay. Frank, what is the best procedure to serve an amended bill of particulars, say, for new medical information received after you served your initial bill of particulars? Is an order to serve an amended bill of particulars required? No, so what we do is, and it wouldn't be an amended, it would be a supplemental bill of particulars. So you'd be supplementing the injury section. So what we will typically do is we represent a client, they were in an accident, they broke their leg, and they had surgery. So in the bill of particulars, we would list the surgery, the injuries that caused the surgery, when the surgery was, all of that. And then a deposition happens, even an IME. But let's say during that time period, the client says, listen, my surgeon told me I need to come back in. I'm having problems with the hardware. It needs to be removed. I need a second surgery. They go in for that. So then what you need to do is you need to notify your adversaries. You could even do an email or call. Hey, a heads up. My client just had another surgery. We'll be supplementing our bill of particulars. And I understand you do have a right, if you want it, for a follow-up deposition and a follow-up IME. So then you go to your bill of particulars from the first one. You see it was number 12 was the response to their question about all the injuries. And then you say plaintiff hereby submits the following as in for his or her supplemental bill of particulars, number 12. In addition to stated in the additional bill of particulars, the plaintiff is required to undergo surgery on such and such date for replacement of hardware and all the other damages maybe that flow from it. Maybe there's more medicals now. Maybe there's been more therapy. So you want to make sure you update everything and you do it through a supplemental bill of particulars. And just know that your adversary is entitled, even if the note of issue has already been filed. If you're going to put in another element of damages and another injury, your adversary is entitled to the additional deposition and IME limited to that. That's the best way to handle that. All right, Lily, for non-party depositions where you need a subpoena for the EBT, how do you draft a subpoena if it is going to be in a virtual format? Lily, that's really easy. Just take any sample notice of deposition that you use, tailor it, and then what you would put in there is, the plaintiff intends to take the deposition of the non-party witness on the below date and time or on April 15th, 2026 at 10 a.m. via video recorded streaming service such as Zoom or Google Teams. So there's various ones. If you want to shoot me an email, I can give you a sample one we've used. So that's all you do. You can do that whether it's for a non-party subpoena or whether it's for a regular party deposition. Just put in the notice of deposition that it's going to be recorded via Zoom or similar online format. All right, Michael, in a deposition, what if the other party's counsel attempts to intervene or object to limit what can be answered by the deposed? I had this happen many times and ended up arguing with the opposing counsel that this is not his or her deposition. Great question, Michael. And, depositions can get pretty crazy. So keep this in mind, everybody, that if you're in a deposition and there becomes an issue, careful of what you say, because it's all going to be taken down in the transcript, and likely the judge is going to see that at some point. So the first thing I would do in that situation, if you find yourself in a deposition, a situation where another lawyer, your adversary, another lawyer in the room, if it's multiple parties, sort of hijacking and saying, well, I think the witness didn't finish answering and should really be giving an answer about this. And why don't you show the witness the document first before you ask them the question? Or I think X, Y, and Z. Or I don't think that's an appropriate question because, and they go on and on. You need to nip that in the bud right away. I put my hand up and I said, counsel, I'm going to say this once. You're not allowed to give speaking objections. This is not your deposition. I will ask the questions that I'm entitled to ask in the order and in the manner which I want to ask it. If you have an objection under the rules, it needs to be short and to form. All their objections are preserved. You can say objection, then your witness has to answer. And I don't want you interrupting the witness, interrupting their answer, interrupting me. Thank you. And then you just move forward. Now you've made that statement. It's there if you have to mark things for a ruling. If they start obstructing and they don't stop, you say, counsel, I'm going to bust the deposition now because you're not allowing me to proceed with my questions. Despite the rules, despite your consenting to the usual steps, you're giving speaking objections continuously. You're continuously cutting in and stating things to the witness during their answer, and you're interrupting my flow. And so I've given you fair warning. I've made my record, and now we're going to stop it. And I'm going to make a motion to the court that we come back with a court monitor and that you pay for the costs. So you can try it that way, or you just get through it and you make your motion. But that's what you do. You're going to run into situations, especially if you're a younger lawyer or a new lawyer, you may be in where older seasoned lawyers may feel they can try and take advantage of you. Don't let them. It's your deposition. You ask what you want, you get the answers you want, and don't let them convince you about what you can and can't do. You have to be strong about it, okay?
Attendance code number 2 is DEP 133. That's DEP 133.
All right. Michael, how you doing? Is it valuable to object to form to prevent potentially harmful testimony from being admissible in a summary judgment motion? Find that many attorneys don't rephrase the question when the form is objected to. Yeah, it's a tactic. So if they ask you something, say objection to form, and then they may move on, they may rephrase it, they may say what was wrong with my form, and you should be ready to tell them. But yeah, you could look, if there's nothing wrong with a little bit of gamesmanship, we are advocates after all. And if you see that your client's getting beaten up and the other side's doing a really good job, you may want to jump in here and there and object to form and just to throw them off. Maybe they're really good without anybody impeding them, but you start objecting a little bit and it throws them off where they're going. So I have no problem with that. That's a good suggestion, Michael. Okay. H. Adeni Taiwell. Here's the question. Why not just list the injured body parts in the bill of particulars? Isn't it defendant's job to get the needed records to find out if there were injections or surgery? Also, if a client gets an injection or surgery after the depositions, you always update the BP. So here's what I was talking about earlier. When you're saying, isn't it their job to get the records? Well, technically, it may be, right? But why wouldn't you give them everything? Why wouldn't you give them everything? Don't you want to move your case? And if you give them all of the records and point them in the right direction of the seriousness of the injury by telling them the surgeries, the date, the hospital, giving them the operative reports, why would you want to sit back and wait for a lawyer who potentially doesn't care or lets the case fall through the cracks and they don't get the records? And then 6 months go by, a year go by, and your case isn't moving. And they're saying, oh, we haven't gotten the records yet. You didn't even want to give them to us. Give them everything. And yeah, always update the BP, always with additional treatment. Here's the problem. If you don't supplement your bill of particulars and you don't give them everything, and then ultimately you end up at trial, you don't win before you walk in. and you go to trial and you want to put in as an element of damages, yeah, and you've been getting injections every month for the last 4 months, right? The defense would rightly be able to stand up and object. They didn't supplement their bill of particulars. We have no information regarding these additional injections or treatment. So if it's anything you need to make your claim stronger, your damages case stronger, give it to the other side. Again, you're sort of touching on one of the things that I see that I don't think is good, which is these plaintiffs sort of sitting back like, hey, let them get it. It's their job. No, no, no. It's your job, right? You're the one wanting to get resolution for your client. Give them everything. Just keep giving it to them. Don't sit back. Don't sit on your laurels. Same thing with the defense. If the plaintiff isn't giving you what you need, there's nothing wrong with picking up the phone. Hey, you haven't responded to my emails and my demands. I want to try and move this case for you. Maybe we can resolve it. But unless you give me everything, all the records, all the authorizations, I can't check my boxes. I can't put this before the carrier to get you authority. Okay? We need to work together, folks. We really do. I can't stress that enough. Both sides of the case. You have to help each other out. Hannah, do you have any tips for when the defendant's documents produced in response to discovery are all redacted beyond what is necessary? Yeah, again, that's one of those where I would meet and confer. I take a look through it. Sometimes things are over-redacted. Sometimes things are appropriately redacted. And in the incidents where there's an over-redaction, you could generally get a sense of what it is. Is it someone's name? Is it just the premium? I know a lot of times you demand like the declaration page from the insurance policy and they'll redact the premium. It doesn't really matter. So the question is do you think there's something redacted that's important? That's what you have to determine. And if you do, I'd pick up the phone, again, call your adversary or send an email whenever we can have a meet and confer. There's a lot of redactions. I think there's too many. I have just a few that I wanted to know if you would consider removing. Can we talk? And then you could say to them, look, this is in the section of incident description and you redacted the whole thing. You know, this is the whole reason we need it. Would you agree to give it to me unredacted? Otherwise, we have to bring this to the court's attention and go from there. Okay. All right, cruising right along. Thank you for all these great questions. All right, Charles is asking, at a depot, do you prefer to sit in the conference room with your back to the window so as to avoid distractions going on outside? That's a great question, Charles. I don't know. It depends where you want to be, whether you're in a room with windows, if you have a choice by the time you get there of where you want to sit and you're the questioner or you're defending, personal choice. I don't really have a preference of whether I'm questioning or defending or the window's on one side or not. Doesn't really make too much of a difference to me. Again, go with what makes you and your witness comfortable. I'd speak to the witness too. If it's your witness who's being questioned, you'd be like, would you rather face the window or be away? Do you have a preference? I don't think it's really a big deal one way or another, just personal preference. All right, Jalila Bell is asking, are there best practices in discovery for ensuring that you can lay a proper foundation for the introduction of your photographs for trial? Great question. Yes, yes, yes. So let's say, generally speaking, if something is provided to you in discovery, let's say it's an auto accident case, and in discovery, the defense provided to the plaintiff photographs you demanded photographs of the defendant's vehicle showing any damage, and they send it to you. For the most part, there's usually not any objection to putting that into evidence at trial because it's really authenticated by the fact that the defendant is telling you, this is our client's photograph depicting the damage. It's a representation. However, let's say that your client gives you chat messages, right? And there's a chat message that includes the witness or the defendant in it that you got from your client. And you know you're going to want to use those in a motion for summary judgment or at trial. And there's some good stuff in there that this witness said in the chats that your client gave you. Then you've got no other way to authenticate it. You can try through your client and say, yes, this was from that person. But the best case scenario would be you show that to the witness and say, this is a text exchange you had, right? And this is what you said is in the blue bubbles, right? Right. And you said this, can you read it? Right, right. So you authenticate those things through a witness. So absolutely, if it's photographs, if it's incident reports, if it's something that they signed, that's what you want to do. You want to get it out from them. This is your document and you signed it. And this was generated in the ordinary course of business. So that's a great question. And it allows me to expand on something I think is super important. Is one of the reasons you're doing depositions is to get your evidence, to get it authenticated. It's to get the evidence you want to use in your EBT, in your motion or a trial. Okay. So when you have a witness authenticate something at a deposition, there you go. You're good to go. All right. Senior Ruth Lout. Oh, you're just commenting on me being a great presenter. I really appreciate that. Thank you so much. All right. Charles is back. What you got, Charles? Do you think the day will come when depositions are taken and defended by AI robots? So it's a really good question. You talk about AI. I don't think so. I don't think so at all. AI is a great tool. I may have mentioned, be on the lookout. I'm creating my own AI tool for all of you that will have my internal methodology for preparing for trial and depositions available to you to help you generate these outlines I'm talking about for depositions and for trial. If this is something that sounds of interest to you, I'd appreciate the feedback, however you can give it. But AI does a lot and is starting to and will continue to do a lot for us. But my view of it is that AI we will use as tools, the same way we use Zoom as a tool for the CLE. But robots and AI will not be doing our jobs for us. And I don't think AI will ever replace what we do as lawyers in a courtroom or at depositions. I strongly believe that. I think they will just continue to serve us as assistants and tools. Thank you for the nice comments, Jocelyn and Lorraine. Everyone's saying super nice stuff. Thank you. Thank you. All right, Stephanie. The judge has every lawyer who makes a motion and schedules a hearing draft the order after the judge makes an oral ruling. So, Stephanie, this is getting back to the order. They didn't do it. You can't force somebody to do something, so you have to, I would e-file a letter. That's what's great about being online. E-file a letter saying, despite list all of your attempts, and despite the court's rules that the moving party draft the order, defense counsel made this motion. They lost it. It was and they refused to do the order, or find out, maybe call the judge's part and say, if I draft it, can I draft it and submit it along with a cover letter? So those are potential ways you could proceed. Joel Iannucci. Hey, Joel. I would remind everyone of the importance of trying to make sure that the Q&A in a deposition will be admissible in a motion for summary judgment or trial. A follow-up question on an important Q&A to create clarity is always a good idea. Yep, just make sure you've got a nice, crisp question and a nice answer. Also, make sure that you send out the transcript to the witness to sign and execute it and send back the sign page and any changes on the errata sheet. It's pursuant to CPLR and the federal rules. If you're in federal court, there's a time period by which if they don't make any changes and sign it and send it back to you, it's deemed admitted that everything is accurate as it is after a certain period of time, either 30 or 60 days. So you want to make sure that if you're submitting deposition testimony and attaching that as an exhibit, that your adversary can't come back and be like, no, there are changes on the errata sheet. So make sure you double check all of that first. All right, Kenneth Burness. Our general demands are omnibus names by another name. I was taught to call them omnibus demands. Yeah, omnibus demands. I see we don't use that terminology in my firm, but my understanding when I get a packet of omnibus demands is that inside of that are all a bunch of individual demands. So usually it'll be omnibus demands, and then like centered is like a section title would be demand for authorizations, then a couple paragraphs down, demand for experts, a couple paragraphs down, demand for whatever else. So I generally see that as omnibus demands. We don't do that. We serve individual demands for everything. Demand for notice of discovery inspection, demand for experts, demand for insurance pursuant to CPLR. I think it makes it a little bit cleaner, following up on things, as opposed to saying you didn't respond to this portion of the omnibus demands dated this, then you have to attach all the omnibus demands. It's just a matter of preference. Okay. Right, I'm actually going to do two quickly because
Okay.
they're important.
Go for it.
I want to point out that I'm not against when people call me out on things, bringing those up. So Robert Weiss said, no disrespect. I think you do a very nice job, but I disagree with the suggestion to supplement the bill of particulars to specify injections or other treatment. The BP is for injuries, not treatment. Listing specific treatments can create unnecessary issues if others are not listed. Also, since defense attorneys are on this as well, I don't need them thinking your suggestion is required. It isn't, and now they might later argue that this is how it must be done. God help me if one day defense counsel stands up and yells to the judge, I was in a CLE with plaintiff's attorney, Andrew Smiley, and he said if they didn't supplement, it's not coming in. So it's not coming in. Hopefully that'll never happen. But thank you, Robert. Look, these are all calls we all have to make as lawyers. I'm going to continue supplementing and suggesting that, because if it's something important and it's a serious element of damages, and injections are. I don't know if anyone's looked at a life care plan of what injections cost. Botox injections, epidural injections, but they could cost several $1,000s a pop and are often needed multiple times. And it's serious when they're putting a needle into your spine. So I would hate not to be able to talk about that at trial if I didn't supplement it. So if you're not supplementing your BP, at least send them updated records of everything. Make sure you're disclosing it somehow. So if it gets to the point of trial where they're saying, hey, they never told us about this, you could say, I gave them the authorizations and the records. Last thing from Emily, if a defendant asks your client at the end of your deposition, do you have anything you want to add to this deposition? What do I say? I say objection to form. It's not a proper question. Do you have anything you want to add? What is that asking? You could say, are there any injuries you've sustained that you haven't talked about yet? You could say, are there any damages that we aren't aware of that you haven't discussed? Same thing on the plaintiff side. Are there anything you observed about this accident that you haven't said? But an open question like anything you want to add, anything else is improper. So I'd object to that. All right. Thank you all for your time and staying in and hanging in there with me. I look forward to seeing you next month.